Hey everybody, Harry here to talk about a really crazy and really expansive preliminary injunction entered by a Trump judge in Louisiana over the weekend, entered on July 4th, in fact, in response to a lawsuit by a few Republican attorneys general. What are they claiming, or what's the lawsuit about? Well, both the Trump, but especially the Biden administrations, you'll recall, did what responsible governments do. They worked with social media companies, including during COVID, to try to give them possible ideas about policing anti-vaccine false information that they were spreading that obviously presented a danger of public safety. That's the sort of core thing. But the suit is very broad gauged, and it says essentially that the government and social media companies are together in their work suppressing conservative content in violation of the First Amendment. And this one, the judge agreed and entered a broad injunction against the federal government, and it's very kooky in many respects. But one of them is the judge has said that in these different efforts to work with social media companies, at the end of which it's clear, at least it's the government position, the social media companies decide what to do under the law. The government has somehow suppressed speech and in violation of viewpoint discrimination because they are actually suppressing content that has conservative, at least it's from conservative websites and the like for instance, vaccine deniers. It's an interesting notion, by the way, that false speech is considered to be actually conservative. But leaving that to the side, the real there are many ways to try to either understand or criticize this ruling, but one of them is we're talking about very, very routine government communications and collaborations with business here. Social media, which by the way, has a constitutional right to petition government, has been recast by this fellow in Western, I think, Louisiana, as government suppression of free speech with some pretty hyperbolic. So he issues this very sweeping preliminary injunction. It goes to not just agencies but officials, the Surgeon General, that avatar of anti-conservative thought, White House press secretary, DOJ, FBI, and the whole notion is, as the judge writes, during the pandemic, the United States government seems to have assumed a role similar to an Orwellian ministry of truth. So this is really, basically a ruling from another world in which the government, it's an extremely Trumpian world in which the government is just about trying to suppress conservative speech and important ideas like how terrible vaccines are. And in its work-a-day relationships with companies and social media companies who, again, can do as they will at the end of the day, and want to try to comply with the law, want to help and further the public health goals of government and them, are working with and deciding what to do. This somehow is converted into Orwellian evil speech suppression. And the different topics that the judge points to as being suppressed were, he says, conservative, which is quite telling. So he talks about not just opposition to COVID vaccines, but the lab leak theory, masking, lockdowns, opposition to the validity of the 2020 election. I'm not really sure what that would mean. I can't imagine the government was trying to suppress that. And course, statements claiming that the story surrounding a laptop belonging to Biden's son, Hunter Biden, was true. Okay, just another point, of course, the First Amendment protects accurate speech, factual speech. So if there are efforts to help social media weed out literally unfactual fiction by conservative, wild-eyed websites, it's very hard to see how that would count as First Amendment suppression, much less viewpoint suppression, but that's the world we live in. All right, so what's happened? He's entered a preliminary injunction. As of this moment, government may not do any of these things. It really goes to show and this is a whole separate topic, but the vast power of a single federal district court judge to really freeze the linebackers throughout the country. We've seen this in some of the abortion litigation. The United States will probably appeal this in short order to the Fifth Circuit, which is the circuit that is above this judge. The preliminary injunction represents not just his putting things on ice, but his preliminary judgment that the plaintiffs here, the attorneys general, are likely to win the lawsuit. So let's say the Fifth Circuit dissolves the injunction and says you can't freeze things. Nevertheless, the lawsuit then goes forward in the hands of this pretty dangerous, wild-eyed guy, and who knows what it will look like then. He could still enter a judgment on the merits, which would then have to go up to the Fifth Circuit. But anyway, we should all look for the very broad injunction, basically telling the United States government and so many people in it just can't be working with social media companies on topic after topic. We should look for that to be dissolved. If it isn't, we're in a world of hurt in this country. But I just can't imagine that this stands. We'll see. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.